Good afternoon, everybody. This is Whitney O'Reilly. I am the chair of our wealth preservation section here at Cohen Seglius. I'm going to just talk for a few seconds before we get started. I'll pull up the slideshow. Today's Lunch and Learn, we're talking about preparing and protecting your estate plan in rising interest rates. We're going to spend a little bit of time talking about what an estate plan is, why we care about that, and then moving forward, what are some strategies that we can utilize moving forward? Again, if you have a question, feel free to put it in the chat or the Q&A. Most of us now have been on far too many Zooms that we know far too much about this space than we would like to. If it's a question that I think is pertinent or I'm able to look at it and respond to the group, I'm happy to do that. Certainly feel free to reach out to me at any time. You can just type my name into your Google search bar, pull me up and shoot me an email, give me a call. I have been practicing in the estate world for 15 years now, and I've been doing this and only this. So I draft your will. When you pass away, I file your tax return and administer your estate through the probate process. If there are trusts, I may draft those trusts and administer those trusts. And I also run our estate litigation department, where we have things that happen like having to get a formal guardianship when somebody's incapacitated and they don't have a power of attorney document, or when assets are being given to the wrong person, or a valid will has been destroyed, going through that litigation process in regards to estate work. So I think it's been a couple of minutes. I think it's been enough time for everybody to hop on in. Again, I try to do these every couple of months. Normally, I look to something that's going on currently with our world, as in interest rates rising, and speak to that. Sometimes it's a case that I'm working on, or it's a question that I've been asked many times in client meetings that I just think, wait a minute, let's get a webinar so that we can answer these questions for the greater good. Again, if there's ever a question or a topic that you want me to speak about, I'm happy to do that. And without further ado, I am going to pull up this PowerPoint. If anyone wants the recording or the PowerPoint slides after, they are loaded onto Cohen Seglius's website. You can find them. If you have any issues finding them, certainly feel free to reach out to me. I can either answer your questions or point you to the right spot. I feel like this information today is actually awfully pertinent. A few short days ago, I had a bit of a medical scare. I'm fine now, a little bit tired today, but I had a bit of a medical scare. And in the middle of that situation, one of the things that I thought about was, I've got an estate plan in place. My spouse knows where those documents are. I've got the right people in place. I've got the right protections in place, and I have a tax efficient plan. So it's something that everybody should have. Whether or not you need these advanced strategies, everybody should have a plan in place. Because thankfully, nobody had to use a medical power of attorney for me. Nobody had to use a living will for me and determine whether or not I'm an organ donor. We didn't have to probate my last will and testament in order to give my assets to, let's say, my spouse or down to my minor children, but it's there in place so that either whatever's happening right now can continue to happen. Somebody can continue to pay my bills so that if I was hospitalized for a period of time, someone could continue to take care of my affairs, right? And if I passed away, somebody can administer that estate for me. So it feels awfully pertinent to me today. It feels that way most days. And on any given day, I see between 3 to 5 clients. We're either drafting wills, administering estates, or working on trust. So this is something that I'm surrounded by on a daily basis, but not everybody else is surrounded by this on a daily basis. So sometimes it takes that medical emergency. Sometimes it takes a family member or a friend passing away or getting sick to remind ourselves how incredibly important these documents really are. And so let's get into what those documents actually are. So here I'm going to share my screen. and we're going to get started. All right, preparing and protecting your estate plan in rising interest rates, right? So estate planning strategies, the ones that we're going to talk about, they rely on interest rates in order to calculate the value of assets that are either gifted or loaned to family members or to a trust. So fluctuating interest rates remind us that we have to review our estate plan from time to time. And remember, the Federal Reserve Bank took a wait and see approach anyway to further raise the rates as it held its overnight interest rate steady, at least in November. So that's what we know right now, but we know that there could be more interest rates hiking on the way, and they are higher than they have been actually since probably before I was practicing as an attorney. So very pertinent to us today. Again, I've been doing this for a really long time. A lot of you come to my webinars, pay attention. Once in a while, I ask a question and you can win a prize. But even more important than that, you're getting really good information that is really important to each and every one of you, whether you are married or not married, whether you have children or not children, whether you are worth 50 million or 1 million, all of this is relevant. So I really appreciate you being here, listening. Today, I am in our Philadelphia office. I'll have to make my rounds into each of our offices in each of our states so that you can get a glimpse of a little bit different spots. But again, we practice right now. I'm in Philadelphia, so I'll probably speak to Pennsylvania a little bit more, but we practice in Pennsylvania. We practice in New Jersey. We practice in Delaware. We practice in New York. We practice in DC, Maryland, and Virginia. We also practice in Florida. I feel like today would be nice in Florida, 80 and sunny or something like that. Just remember, your estate plan is state specific. So if you lived in Pennsylvania and now you live in New Jersey, even if it was only a couple of years ago, you should revisit that plan because the documents are state specific, as in there are different rules in different states how these documents work. And so the document might not work the way we want it to. So you've got to review it. One, it's good to review an estate plan every once in a while anyway. But if you move from one state to another, it's time to give that a look with either an attorney that you have who's able to practice in that new state, or you'll have to move to another attorney who is practicing in that state. Remember, as lawyers, we have to be barred in particular states in order to practice. So not every attorney is licensed in every state in the United States. Okay, so let's start with what is your estate plan? That's a very simple question and a simple answer. I hope a lot of you already know this. I have done webinars on the difference between a last will and testament and a revocable trust. But remember, these are the basic documents that you should have. If you don't have all of these documents, then you don't have a comprehensive estate plan, and it is something that you should update. So remember, we've got that financial power of attorney. If you own a business, could be a business power of attorney as well. We've got a medical power of attorney, so somebody can help you make medical decisions. That financial power of attorney allowed somebody to help make financial decisions for you, help continue to run the business for you. You might also have an operating agreement that says what happens, shareholders agreement, board of directors agreement. You may have lots of business paperwork that says who's in charge of making decisions if you become incapacitated and if you pass. And we want to make sure all of those documents are coordinated together in one estate plan. Again, just talking about my minor medical issue a few days ago, that medical power of attorney could have been very important. If I was not able to communicate, I'd want somebody to communicate my wishes. Who is that particular person? And a living will, it's also known as an advance directive. You'll want one of those that says what you do or you don't want at the very end stage of your life and whether or not you're an organ donor. Some other states, like New Jersey, have some new legislation called the physician-assisted suicide. And I did do a webinar on living wills talking about those PAS rules. Sometime in the future, there may actually be documents related to those PAS laws. For now, there are not. There are only a few states here in the United States that allow physician-assisted suicide, but it is something coming our way. You could also have something called a do not resuscitate. So if you have come to me, if you have a stage 4 diagnosis of, let's say, pancreatic cancer, and we know that the end is coming soon, with having all of these documents in a living will, you may also have something called a do not resuscitate. So that do not resuscitate says, even if you can bring me back, please don't. I am passing away from this cancer, and I don't want to be brought back so that I could be alive for another week or 2 weeks and have the same thing happen. I'd like to die with a little bit of dignity. Remember, the living wills came from that death with dignity law. Both the financial power of attorney and medical power of attorney have had recent legislation. The financial power of attorney much bigger than the medical power of attorney legislation. That legislation said if we don't specifically say a number of, we call them hot powers, they're not included in your financial power of attorney. And what that really means for you is if you have a power of attorney that was drafted more than 5 years ago, then it may not work at all. It's not invalid, but if it doesn't have those powers that it wasn't required to have before, then we can't utilize those powers. And those powers are basically the things that we need to do for someone else if they were incapacitated. So that one's really important. Medical power of attorney, we had our most recent piece of legislation go through anyway here in Pennsylvania. And so we should update that as well to just account for some organ donation issues. And then again, we're going to talk about advanced planning today. And many of those advanced plans involve something called a trust, an irrevocable trust. And in that irrevocable trust, we can have a lot of different things happening, and we're going to see that in this advanced planning. And then again, we've got that last will and testament that says what happens with your things when you're not here anymore, and who's in charge of it. And you may also have a revocable trust, which does the same thing. It just avoids probate. It could avoid some other things as well. I think I've done a webinar on the differences between the last will and testament and a revocable trust, and even a revocable trust and an irrevocable trust. So give any of those webinars a look. And if you have any questions, certainly reach out to me. But so there we go. Now we understand a little bit that we've got an estate plan in place. Or if you don't, these are the documents that you need. Why it's really important from time to time to update those documents. And then we're going to talk about really the main reasons that we have these documents in place, right? Because we want to make sure we've got the right people making the right decisions for us. When it comes to passing our assets, we want to make sure that they're passed in the most creditor-protected, tax-efficient ways. So what do I mean by tax efficiency? When you are living, you pay income tax, right? You pay it at the state level and the federal level. The same is said for when you pass away. There are death taxes involved. They are called the inheritance tax or the estate tax, or could actually be both, right? So they're the death taxes. So here I'm showing you in the slide, we've got some exemptions. So first, there is a federal estate tax. Right now, the tax is a 40% tax. It's something like a flat tax, not quite like that, but let's say it's that for now. So 40%. But right now, we have a federal estate tax exemption of $12.92 million. So you might say, oh, geez, I have under that amount of money, so I guess I don't have to listen to Whitney and about these advanced strategies. And the answer is, no, that's not the case. What is actually happening in the Tax Cuts and Jobs Act is that created this exemption. It's sunsetting. So it's going to sunset back down to $5 million at the end of 2025. So January 1, 2026, we only have $5 million. It is adjusted for inflation, but just remember that $5 million, if you count your house, life insurance, investments, you can get to that number pretty quickly. Or even if you're close to it, you want to make sure that you're accounting for it, because remember, it's a 40% tax. We also have something for the federal estate tax called the unlimited marital deduction. The unlimited marital deduction means anything that passes from husband to wife is not subject to that death tax. It is only subject at the death of the second spouse. Just be careful here. because some trusts that were created a long time ago don't have the right provisions. These are called spousal trusts, and they need to have specific provisions in order to qualify for this exemption. So if they don't qualify, it could actually trigger a tax. So it's always good to go back and look at your plan and make sure you've got the right kind of trust in place for your family members. There is also something called the federal gift tax. It used to be something 1976, it was unified with the federal estate tax. So it's the same number. And if you give it away during your lifetime, it comes off after you pass away. So for example, if I give $1 million to my daughter, and then I pass away, then I have only $11.92 million to shelter from that federal estate tax. Pre-1976 rules were a little bit different. There's also another tax, and we'll stop at gift tax for a second. This is a question that I get frequently. How about on the state level? If I give a gift to somebody, do I have to pay a state gift tax? There's only 2 states here in the United States that have a gift tax. It's Connecticut and Minnesota, I believe. I don't practice in either of their states, and none of our other attorneys in my practice groups and any of my offices do as well. But if you live in those states, that's important to understand as well. Anytime you give something to someone else, there's a tax consequence. We do have the annual exclusion from gift tax. It's a really simple way. We're actually getting close to the end of the year. It's a really simple way to transition wealth to the next generation without paying any tax, right? Any gift tax or death tax. And that's $17,000. It can be given to anyone in the entire world. It can give me you and your spouse. So my husband and I could each give $17,000 to my daughter and to her husband and to her children. So that number can be very big depending on how many children that you have. So it's in a very easy way to transition wealth, and you can do it once a year. Then we've got this thing, I'm not going to spend much time on this, called the generation skipping transfer tax. It's called the GST tax. Very, very complicated, and comes into play when we are giving money to successive generations instead of the generation below us. So the example here would be, instead of me giving $1 million to my daughter, I create a trust for my grandchildren and I put $1 million in it. That is subject to the GST tax. Again, I'm oversimplifying most of these things because we only have a short amount of time to talk, but we also have an exemption for that as well. That's a $12.92 million exemption. And again, you can use up GST exemption and not estate tax exemption, or vice versa. So it can get very complicated. The DSU number, that's the deceased spouse's unused exemption. Plans before 2012, we had to have something called AB trust, or some kind of automatic marital trust funding, in order to take each individual's exemption and give it to their surviving spouse. In 2012, we created something called portability. So for federal purposes, without having a spousal trust, you can file a federal estate tax return, that's a 706, in order to elect portability. And that portability says, if I pass away and I gave $1 million to my daughter during my lifetime, but the rest is going to my spouse, basically what it says is we can port over that $11.92 million, can be put on top of my husband's $12.92 million, so that when he passes away, he always has my $11.92 million that we can shelter from that tax, and we can add it with whatever his exemption is at that particular time. Right now, it's 12.92, but what I hope is my husband doesn't pass away for a long time. He's pretty young, and that exemption may be back down to 5 million, right? So we've then got his 5 million, but we've sealed in, we've locked in place the amount that I can do. So that's very, very important. General practitioners miss this all the time. If one spouse passes away, everything is owned in joint names. A lot of times they'll meet with an attorney, and the attorney will say, everything is great, there's nothing that you need to do. And the answer is, there may be. You may very well want to do an estate administration electing portability so that you can capture that unused exemption. If you don't do it, you lose it. So in 20 years, if you decide, oh, geez, we actually made some really good investments. My husband and I own a brewery. That brewery actually did really well. And we could really use that. If you didn't elect portability, you can't use that unused exemption. It just vanishes. So that's very important. Right now, we do have a oopsie provision, which is if we forgot to do it, or maybe weren't reminded to do it, if we do it within 5 years of the person passing, then we can still elect portability. So you want to think about that if somebody has passed away recently. The history of the federal estate tax. I just like history a little bit. Really, the federal estate tax came into being in order to fund our Navy in the 1700s. Then it was abolished. It came back in order to fund the Civil War, and then it was abolished. And from 1916 on, we've had some form of a federal estate tax. We had it all the way up to 55%, down to 35%. Again, right now it's at 40%. I do believe at one time it was 80%, so a pretty big gnarly tax. The only year we didn't have a federal estate tax was 2010. And George Michael Steinbrenner, who was a businessman, and many of you know, was the owner of the New York Yankees, the baseball team. He died in 2010. So he did not lose 40% of his $1 billion, and the full value went to his family members. So just an interesting tidbit for us. Here we've got the state level death tax. Remember, we practice in a lot of states here through Cohen-Seglius. And there are state taxes that we have to worry about. For Pennsylvania purposes, it's called the inheritance tax. It's a tax on the beneficiary. So it depends who you are, what the tax is. So if you are a child, it is a 4.5% tax. If you are a spouse, it right now is a 0% tax. It used to be a 6% tax. If you are a sibling, it is a 12% tax. And if you are simply a friend, it is a 15% tax. For New Jersey, we actually have 2 states that we practice in that have both an inheritance tax and an estate tax. And then on top of that, the federal estate tax. So lots of taxes going on here, which is why we do some of these advanced strategies. So for New Jersey, we have an estate tax. It was abolished for anyone who passed away after 2018. So now we just have to worry about the one unless there was a trust created before that time. The New Jersey inheritance tax, that's 11% to 16%. But many people are actually exempt from that tax, as in if you are a spouse or children, you don't have to pay that tax, and the tax goes up depending on who you are. Maryland inheritance tax, it is that 10% tax. It's just for collateral heirs. So again, it's kind of like the New Jersey inheritance tax, where it's only if you're giving things to other individuals. I normally call this provision the takers of last resort clause. You know, if a plane went down and no one in your family survived, if you gave everything to, let's say, friends, it would be subject to this tax. Maryland also has the estate tax. They actually have an exemption. Used to be the same as the federal estate tax, but it's not. It's a $5 million exemption, and the amount of assets that you have, it goes up from 0 to 16%. DC also has an estate tax. The exemption is 4.58 and a little bit more $1 million. Again, that's 11.2 to 16% tax. New York has an estate tax. The exemption is 6.58 million. That one goes from 3% to 16%, again, depending on how many assets that you have. Virginia, Delaware, Florida have no death tax. But remember, it's really important, even in the states that have these taxes, or let's say don't have these taxes, there are still probate fees or could be probate taxes. So will there be anything left for you to protect? And the answer is yes. If you listen to me and you watch these webinars and you update your plan, you'll be able to transfer a lot of wealth to your family members at the least amount of tax humanly possible. So trust, just a little bit about trust as we dive into these advanced strategies. The term trust really came over from the Roman Empire when Roman soldiers would go off and they'd leave their land to a trusted friend to take care of their family members. That sort of came over into the United States when we colonized and thereafter created trust. There's a uniform trust model law here in the United States. Many states have adopted a version of it. And so that's what we have to look at for state purposes. Pennsylvania, that's the Uniform Trust Act. That's inside the PEF code. That's called the Pennsylvania State and Fiduciaries Code. New Jersey also has the Uniform Trust Code. New York in their EPT, that's in Article 7. Again, this is what we're going to look to for the laws regarding some of these trusts. And now let's talk about some of these estate strategies. So now we know that I've spent a lot of time in this practice group. I've had some recent medical experience saying that these documents are really important. I would like to think that I'm very young and healthy, but just a few short days ago, we thought maybe that wasn't the case. So we never know, and unfortunately, we will all be subject to needing a last will and testament or a revocable trust. So again, these documents are really important. And now we get into how can we make sure that we are maximizing the amount that we can pass to successive generations? What is the best creditor protected environment to pass on wealth to successive generations? So for the whole time that I've been practicing, these estate strategies were really what we did because we've been in a low interest rate environment since 2010 until now. These are the strategies that we were employing. It doesn't mean that if you have one of these, you shouldn't, or if you're thinking about creating one of these, you shouldn't. We just have to understand how they work and what is happening now that we're in a higher interest rate environment. So we've got the intra-family loan. We've got something called a GRAT. That's the Grantor Retained Annuity Trust. We've got something called an IDGIT. That's an intentionally defective grantor trust. Intentionally defective, who would ever do that? Well, I'm going to tell you why you do it. And a CLAT, a charitable lead annuity trust. So these are some strategies when the interest rates were low. Reason being, an intra-family loan. So it's not a gift. So you need a minimum amount of interest. And the IRS sets the minimum. It's below a commercial lender. And it's known as the applicable federal rate, and it's based on the prior 30 days average market yields of corresponding U.S. Treasury obligations, like a T-bill. So the IRS has these posted on their website. Let's just use an example because I wrote it down. For April, 3 to 9 year loan is 4.15%. This past April, any growth above the borrower gets. So it's not part of the lender's estate. We don't have to file a gift tax return. But the problem is, as interest rates rise, which they have done, so will the AFR, which becomes less effective. Because if there isn't anything above that, what are we gifting the difference? So that may go by the wayside a little bit more. A GRAT, and we've got a GRAT, the Grantor Retained Annuity Trust. One of the coolest experiences I had in my life involved a GRAT. We had a client who invented something, and I got to go and see this invention that produced hundreds of millions of dollars. And we were able to utilize this strategy in order to transition wealth to successive generations. Using this, it's called an estate tax freeze technique. So what a GRAT is you put market securities, well, you can put anything. Put securities, highly appreciating shares of a business in a trust. The grantor gets an income stream back for a duration. That's the retained annuity. What is left passes possibly gift tax free. We can do a whole webinar on GRATs. There's something called a zeroed out GRAT. You can also not zero a GRAT out and pay some gift tax for it. So we'll talk about that a little bit later. But the interest that needs to be returned is calculated by the Section 7520 rate. And what is that? That is 120% of the midterm applicable federal rate, the AFR. So 5% for April in 2023, and the interest rate is fixed for the GRAT term. So it's really good when rates are low because it has to outperform in order for it to work. These are really complex to draft. They're complex to administer, but if it doesn't work, you really just out the cost of its creation. And so one very famous case that really created this ability for us was the Walton family. And the Walton family owned Walmart. And so they tried to utilize a GRAT in order to transition Walmart stock to successive generations. Actually, in Walmart's case, it didn't work, but it paved the way for the rest of us to be able to do that. But again, that's something that really needs to utilize that low interest rate. I'm actually going to flip, I think. Here we go. We've got a grantor retained annuity trust. Again, this is an estate freeze technique. We've got the grantor here transfers the asset into this GRAT, into this trust. That's why we were just talking about trust as part of our comprehensive estate plan. What is it? Goes into this GRAT. We get a annuity payment for a set term, and it's again based on that section 7520 of the Internal Revenue Code, which we just talked about what that is, comes back to the grantor. So the appreciation passes to the beneficiaries free of estate tax at the end of the term to the beneficiaries, 0 tax instead of 40% tax. That's pretty awesome. Then we've got the IDGIT, the intentionally defective grantor trust. Who would ever do something intentionally defective, right? It's like the GRAT, but the grantor makes a gift to the trust. And then they can sell or loan more to the trust. It's irrevocable, so it's out for federal estate tax purposes. But the reason we make it defective is because we want it in, actually, the grantor's name for income tax purposes. So there are 2 sets of rules: income taxes and estate taxes. The rules sometimes look awfully similar, but they're actually different. And so this is why this technique actually works. And so what this means is it lets the trust assets appreciate without any income tax liability or the loan based on the applicable federal rate. So it needs to beat that. That's why we need it in that low interest rate category. So again, here's an example of this. Very simple. Transfer grantor gifts 10 million. We do have to file a gift tax return. $10 million comes off their exemption. So they only have, let's say, $2.9 million that they can shelter moving forward. But by putting it in the IDGIT and by paying the income tax, let's just say it accrued of 5%, right? 5% annually over a 30-year period, it would grow to this $43 million unencumbered by income tax liabilities, and all that growth is out from the federal estate tax, which is a 40% tax, right? If we make it a non-grantor trust, it isn't intentionally defective, then the trust actually pays the income tax. So this is still a good strategy, but it doesn't maximize the amount that can go out to beneficiaries. But there could be a lot of reasons that we might want to do a non-grantor trust. So we might want to do a non-grantor trust if we're putting $10 million in this trust, maybe as the grantor, I only have $20 million, and I really don't want to pay the income tax on the trust that is for somebody else. So I might want to give them that $24 million benefit, but I'm not willing to use any of the rest of my funds to pay that income tax. So again, that's the IDGIT. It's another type of planning, again, that we need in those low interest rate environments. And then we've got a CLAT, that's a charitable lead annuity trust. The grantor gives an income stream by the trust to one or more charities for a fixed term of years or for the grantor's life, and then the remainder goes to family. There's an immediate tax deduction. It's immediate, which is very helpful. It's the present value of the remainder to the family. That's a taxable gift. So you do use some of your gift tax. And again, we use that 75/20 rate. So lower means it's a lower gift tax. So again, that's helpful in these low interest rate environments. Again, that could be for people who are charitably motivated. Then we get to what are the strategies that we can utilize in higher interest rates, which we're experiencing right now. It seems like things are maybe plateauing. I don't know if they're going to continue to go up in 2024 or go down. We'll see. We certainly all want them to go down. Unfortunately, I'm not so sure that's going to be the case. But herein lies a chance for us to do some advanced planning. So here are some strategies that work better in high interest rate environments. We've got the Qualified Personal Residence Trust. That's called a QPERT. We've got something called the CRAT, a Charitable Remainder Annuity Trust. We have just giving a charitable gift with a retained life estate, like a charitable gift agreement. And then, of course, we have the old good ILIT, Irrevocable Life Insurance Trust. If you're over a certain amount of wealth, you absolutely should have an ILIT, which is a trust that holds life insurance. And we can use that life insurance to, let's say, pay federal estate tax. We can use it for liquidity, especially for business owners. You may be worth a lot of money, but not have a lot of liquid assets. Who pays that 40% tax if you pass away and your business that is worth $20 million is now subject to a 40% tax? An ILIT is what we use for that. So it can be really helpful on the state level. At least for, let's say, Pennsylvania purposes, life insurance is not included in the inheritance tax calculation. In many other states, it may be, so it depends what state you're in. But for federal purposes, your life insurance is considered your asset for federal estate tax purposes. So it's really important to understand that. And an ILIT is a very easy way to transfer wealth without using any of your gift tax or any of your federal estate tax exemption. So let's first talk about a QPERT. So why is a QPERT better, right? Remember, these estate planning strategies, they rely on interest rates to calculate the value of the assets that are gifted or loaned to the family or the trust. So remember, these fluctuating interest rates remind us that we have to look at what are the best strategies now. So the QPERT can only be your primary or your secondary residence. It's the home. We put it into a trust, and we retain a right to live there for a term. And when that ends, the house goes to the beneficiaries, and the transfer to the trust is a gift, but the gift is reduced by the value the grantor has retained. So the higher interest rate, the higher value of the right to live. So it's the lower value for a gift tax return. So after the term, what happens if mom and dad are still living? And the answer is they can pay fair market value rent to the beneficiaries to continue to stay in the home. And why would you want to do that? Why would you want to pay your children rent to be in your home? And the answer is it's another way to transition wealth to successive generations. So this can be a spectacular thing to do in higher interest rate environments right now. And here we've got this picture that shows us mom and dad. They're going to gift that residence. Yes, they have to file a gift tax return, but because of these high interest rates, their retained interest is going to be valued higher. So the gift is going to be lower. So they're going to use less of their gift tax. And at the end of this term, if they're still living, the house passes to their children, and the growth of the value of your house, which often our houses, we buy them for what? $100,000, and now they're worth $500,000. You bought it for $500,000, now it's worth $1 million. All of that growth is out for the federal estate tax purposes. So again, that 40% tax. Now, what happens if mom and dad pass away during this QPERT period? That just means that the property comes back to them. Yeah, so if they pass away during that period, it doesn't work. It's a little bit like the GRAT. It just comes back to you. So again, that can be a really helpful strategy that we can use in these high interest rate environments. So I'm going to be seeing a lot more QPERTs from people coming to me from other places, and we'll probably be drafting more QPERTs. Remember, just like for the GRATs and some of these other sophisticated plans, it really depends. If you only have a house and let's say $100,000, this may not be the best strategy for you because you're not going to pay federal estate tax. And if you're under that exemption amount, it might actually make sense to keep the asset in your own name, like your house, because what happens after you pass away is you get something called a step up in basis. So if let's say I bought my house, this beautiful house right here, for $100,000, when I passed away, let's say that medical event that I had, I'm not doing well right now. I'm not here anymore. It went a different way. And the answer is, if that house is now worth $500,000 when I pass away, my children, let's say, who are my beneficiaries, get the basis step up of 500,000. So then if they sell this house, they'll pay zero capital gains at 20%. Whereas if I gift it to my children and then I pass away, and then they sell that property, that $400,000 difference, let's say it's worth 500 and they sell it for 500, that $400,000 difference, they are going to pay a 20% capital gains tax on. So we always have to be careful when we're talking about this advanced planning. We want to make sure that we understand what we're doing, because irrevocable planning normally means you can't change it. So if your circumstances change, sometimes there are ways to terminate things, but it can take a little bit more time and it can be a little bit more difficult. So just remember, there could be reasons to do it or not do it. Remember, the capital gains tax is only, let's say, 20%. The federal estate tax is 40%. So if you're exposed to the federal estate tax, you're going to do planning over here to get rid of the 40% tax, not the 20% tax. If you're under that amount, we might care more about this 20% tax than this 40% tax. So again, it really matters on your own individual assets. So then we get to a CRAT. There's also something called a CRAT. And again, this is some charitable planning. If we have a CRAT, instead of a CLAT, the grantor gives a stream of income to a non-charitable beneficiary for a term. Then the rest goes to the charity. When it's gifted, it gets an income tax deduction on the remainder value to the charity. And the annuity amount stays the same, and it's based on a percentage. It's very important. A charity has to get 10% remaining or it won't work. And we use that 7520 rate. It's used to calculate the remainder. So higher the rate, the higher the income tax deduction. So that can be really helpful for my charitably motivated individuals. And we also have the charitable gift with a retained life estate. Can be any home, which is different than the QPERT, right? The Qualified Personal Residence Trust really has to be your residence or your secondary residence. But this can be any home or residence. You get an instant tax deduction based on the present value of the charitable remainder, and it's based on age and interest rate. It is limited to a deduction to 30% of AGI, and you get a carry forward, so it's out of the estate. Family could get other stuff. Use savings on this strategy in order to buy life insurance that, again, we can put in the next strategy we're going to talk about, which is the ILET, which is better. Remember, a CRAT is a little different than a CRUT. A CRUT, the balance of the trust is evaluated each year for that annuity payment. So again, these high interest rate strategies, we've got the QPERT, Qualified Personal Residence Trust, we've got the CRAT, we've got the charitable gift, we've got the ILET, which we talked about a little bit, but let me explain what it is to you. So the grantor can create a trust. That trust can buy a life insurance policy on the life of the grantor. Let's use me for an example. So, having this medical event happen a couple of days ago, I'm thinking a little bit more that my life is fleeting and someday I won't be here. So I want to buy life insurance. But again, I told you my husband and I own a brewery. And it is doing very well. We may be over the federal estate tax exemption, that $26 million, just about at a certain point, maybe well closer to getting over the exemption when it sunsets, both of us together, which might be more like $15 million. So I don't want to buy the life insurance policy in my own name, because again, it'll be subject to that 40% tax. So I can create this trust. The trust can buy a life insurance policy on my life. And when I pass away, It will fund into that trust for, let's say, my children, and will not be subject to a state level death tax at all. I currently live in Pennsylvania, so it would be the inheritance tax. And it is also not subject to the federal estate tax, so I won't lose 40% of it. And at the same time, because my husband and I own a business, let's say most of the value of our $15 million estate, let's say $12 million of it is all wrapped up in the business. We can also use the funds in this trust, those life insurance proceeds, in order to have liquidity to do things like pay bills or pay people off or pay any of the subcontractors, whatever it happens to be. So an irrevocable life insurance trust can be a valuable estate strategy that we've used in the past. It's slowed down a bit as the federal estate tax exemption has only gone up. We've had to utilize a lot of these sophisticated estate planning strategies less, because when we have a big exemption, we care a little bit more about creditor protection. So we may still have trust planning in place. We may be thinking about those capital gains tax, but we don't have to worry about the federal estate tax. Now, as the federal estate tax is going down, anyone who has close to $5 million or more really needs to think about some of these advanced estate planning techniques. So that's very important. So again, we'll sort of look back here. We have intra-family loans. Well, let's start at sort of the beginning. Remember, at the very least, anyone on this webinar, anyone who's watched any amount of it, just remember, you got to have a last will and testament. Maybe you have a revocable trust, or maybe you don't, depending on your situation. Got to have a financial power of attorney, a medical power of attorney, a living will, or sometimes it's called advance directive. And then whether or not you have some of this advanced planning and irrevocable trust, that depends on your particular situation, and it needs to be revisited from time to time. I know clients ask me, Whitney, when should I review my estate plan? I normally say when a major life event happens. Let's say for me, it was more serious than it was. And that might be the time. If, let's say, what I had was a cause of, let's say, finding out that I have some kind of stage 4 cancer. We're talking about pancreatic cancer right now. My mother-in-law passed away from pancreatic cancer, so it might be on my mind at the moment. Let's say it's stage 4 pancreatic cancer. It is certainly the time to revisit my plan because the end is coming sooner than it could be. So that's important. So when a major life event happens, for something happy, it would be if let's say I decided to have another child. If I was going to have another child, I'd want to revisit my plan and make sure that they're included in my plan and that the plan still works the way that I want it to. If we don't have a major life event happening, then I normally say every 5 to 7 years is a good time to revisit it. For anyone who has close to that 5 million or above, you should see your estate attorney before the end of 2025. So we've got a little bit of time to do that, but have them look over your plan. Hopefully the answer is, we did a really good sophisticated plan before. We're in really good shape to maximize what we can maximize in this estate. But at the end of 2025, all of that money that we can use to do some of this advanced planning, we can use up some of that gifting, it's going to fade away. So we want to make sure if we can gift $1 million and not pay a 40% tax on it, maybe we want to utilize that. So just remember that for some of these advanced plans, that we should probably look at them before the end of 2025 to see if we want to use some of this big exemption, because right now we've got $12.92 million that we can do some wiggle room with. 2026, we only have 5. Now, again, it is adjusted for inflation. And we never know what's going to happen. Since I've been practicing, the federal estate tax has only gone up. So the idea of it going down seems counterintuitive to me. So certainly the government could step in, the legislator could step in and change the provisions. They could change them after 2026. Remember, we do have to be a little bit careful having the tax tail wag the dog because we don't know what the future holds. So we want to be really careful when it comes to some of these advanced planning techniques that may be a little bit more unchangeable moving forward, like an intra-family loan, just giving a loan to your kid and having them pay it back at a certain interest rate, and the money that they get can be invested. And if it makes more money than they're paying back, you just move some money from one generation to the next without incurring any of that state level or federal level death tax. A GRAT, that grant and retained annuity trust, that estate tax freeze technique. I put $1 million of my brewery stock into this trust. It pays me back $1 million over, let's say this is a 2-year zeroed out GRAT. I'm going to get that $2 million back. I'm not going to use any gift tax, and any of the growth on that $1 million that I put in there, the $1 million of stock, my company is now worth $2 million. So that $1 million worth of growth, I got my $2 million, my $1 million back. I'm the same as I was before. I didn't use any of my gift tax, and I have the same value of money. I still have $1 million that's subject to tax, but anything inside of this GRAT, that $1 million in growth, 0 federal estate tax, no 40% tax. So a wonderful technique. Again, a little less able to be utilized now in a low interest rate environment. IDGIT, we talked about an intentionally defective grantor trust that we can gift money into a trust, and we can make sure it's out for federal estate tax purposes. So we do have to pay some gift tax, but the growth is out for federal estate tax purposes. Then we can also pay income tax on the assets inside the trust so it can further grow for future generations. And then we have that charitable lead annuity trust. Again, when we are interested in giving a certain amount to charities. Then we have what is really important right now, which is in this high interest rate environment, QPER, Qualified Personal Residence Trust. Take your house, put it inside of a trust. After a term of years, it goes to your kids. All the growth is out for federal estate tax purposes, and you can still live there for the rest of your life. And you can even use some of your money to pay rent after that term, so we can move more money to successive generations without paying any of those death taxes. So a QPER can be very valuable, and I think in these high interest rate environments, we'll be seeing more and more of those. CRAT and the charitable gift. Again, we've got a charitable remainder annuity trust. We're going to give some portion to charity and hold back some for family. Again, we can just give a gift. We talked about that we can just create a non-grantor irrevocable trust. We can just create a trust. Use $5 million of our exemption because we know a lot of it is going to sunset, and we stick it into an irrevocable trust. And it certainly can have a charity component or not. And then we've got that irrevocable life insurance trust. Again, if you have life insurance and you are somewhat wealthy, we should think about getting new insurance held inside of a trust or transferring that insurance policy into a trust, so it is not counted against you for federal estate tax planning purposes. Remember, 40% tax. So if you've made it with me this long, I'm going to ask you a couple of questions. If you get the question correct, I'm going to send you a gift in some form or another. So here we go. First question. What does QPRT stand for? You can put it in the chat box. The first person to do that is going to win a prize. What does QPRT stand for? It was just up on your screen. Anybody know the answer to what does that mean? We'll wait a second, see if anybody can figure it out. There we go. We've got someone, Qualified Personal Residence Trust. Awesome. So remember, this one can only be used for your primary residence or your secondary residence. So it couldn't be the third property you have or the fifth property you have. What happens when mom and dad pass away during the QPER term? What happens with the property? Where does the house go? Does it go back to mom and dad, or does it go to children? Anybody know that answer? Or guess? You could win a prize. So if we create this QPERT plan, we decide we're going to put the house inside of a trust for a period of time. After that period of time, that house is going to go to our children with a perfect strategy. But unfortunately, mom and dad pass away. Right. So the trust terminates and the residence reverts back to the donor. All right. So we've got the very last question is life insurance taxed at your death in Pennsylvania? Anybody know that answer? Is life insurance taxed at your death? Yes or no? And let's see, do we have somebody right? So the answer is actually yes. It is taxed for Pennsylvania purposes. Life insurance is taxable in your estate. For federal purposes, it is also taxed in your estate. So if I passed away with $1 million of life insurance and it went down to my children, that life insurance, that $1 million would be subject to a 4.5% inheritance tax. And let's say I'm over the exemption amount, that $1 million would also be subject to a 40% death tax. So that is very important to understand. And one of those advanced planning techniques, the irrevocable life insurance trust, the ILIT, helps us eliminate that problem. So I appreciate all of you participating today in this lunch and learn, so we could learn a little bit of advanced strategies related to preparing and protecting your estate plan. If you have any questions, you can ask them now. We do have just a few minutes left. So if you have a question, I can stay on for a minute or so. And I hope to, I won't see because I don't see any of you, but I hope you can see me again in the next couple of months. If anyone ever has any questions, reach out. If there's anything that you want me to speak on, I would be happy to do a webinar on that. If you have any questions about these advanced planning techniques, certainly feel free to reach out to me, Whitney O'Reilly, or to our team here at Cohen-Seglius. Again, we are a medium-sized, started as a construction litigation firm, but we are a full range service firm. We have a large wealth preservation department and are happy to service any needs that you have. Again, I really appreciate you all joining me. I wasn't sure how I would feel for this since my little medical event, but it's just really important for us to remember that these things do happen sometimes unexpectedly. It's really important to get your ducks in a row. If money is given from, I just had one last question. If money is given from one spouse to another spouse for federal estate tax purposes, there is an unlimited marital deduction and you're not subject to that federal estate tax. So great question. And with that, I'm going to end us just a minute early. Again, thank you so much for participating. I enjoy putting on these webinars. Thanks again for coming. For those who answered the questions correctly, you are getting a prize coming your way. And again, I do these every couple of months. So anytime you have the ability, pop on, even if it's only for a couple of minutes. If you get a little bit of something good, that's wonderful. And otherwise, enjoy the rest of your day and enjoy this holiday season. Thanks so much, everyone, and have a great day.